Hello, everyone. This is Andrew Needle. I am a board certified civil trial lawyer in Miami, Florida. I've been practicing for over 40 years. And today we're going to talk about a kind of obscure but very important topic relating to statutes of limitations and statutes of repose. Now, what is a statute of limitation and what is a statute of repose? A statute of limitation is a law that sets the maximum time after an event within which you have to institute your legal proceedings, meaning filing a lawsuit. The purpose to encourage plaintiffs to file timely is why we have statutes of limitations. In other words, there's a policy in the law that says people should have some finality to their exposure, meaning how long they can be sued. You can't have something happen 1 year and then 10 years later go ahead and file a lawsuit. Reason being that you can't live with this sword hanging over your head for 10 years. And secondly, because over the course of 10 years, evidence can be lost, people can die, and memories will fade. So the law says that you have to begin your lawsuit within a fixed period of time. Now, the other thing that we're going to talk about is a statute of repose. Statute of repose is kind of the mirror image of a statute of limitations. The statute of repose says you can bring your lawsuit only for a finite number of years, whether you're aware of your lawsuit or not. We'll come back and talk about how you begin the period of the statute of limitations to run, and also how the statute of repose works. So basically, in a repose situation, if something happened, let's say 4 years ago or 5 years ago, and you just found out about it today, okay, if the statute of repose is only 4 years and the event happened 5 years ago, even though you didn't know about it, you can't bring the lawsuit. And this has been held constitutional in Florida. And the purpose is, again, to foreclose lawsuits from occurring when excessive periods of time have passed. But let's talk about the key features of statute of limitations to begin with. Now, the time period in a statute of limitations typically begins when the injury occurs or when the injury is discovered or should have been discovered utilizing reasonable diligence. The length of time for a statute of limitation varies with the type of claim. In Florida, there's a particular statute section 95.11 that lists out all the different statutes of limitations and statutes of repose, which gives you your guide to when you have to bring certain types of suits. Now, the one that encompasses the most lawsuits would be the statute of limitations for negligence actions. There are also statutes of limitations for contract actions. Contract actions have to be brought within 4 years of the breach. Okay. Statutes of limitations for personal injury actions are a bit more complex. As I mentioned a moment ago, they typically begin to run when the injury occurs or when the individual who is injured discovers with reasonable diligence that the injury has occurred. At that point, the clock starts ticking. And under Florida Statute 95.11, you now have 2 years to bring that lawsuit. Now, before March of 2023, the statute of limitations for personal injury actions, meaning negligence actions, excluding medical malpractice actions, which we'll talk about in a moment, was 4 years. It was shortened in 2023 to 2 years. Now, it really doesn't make a whole lot of difference in most instances because people usually begin the process close to when the statute of limitations begins to run, meaning close to when the injurious event occurs. They'll contact the lawyer will be aware of the statute of limitations, and a lawsuit will be filed within the 2 years. However, okay, in certain cases, you can't always determine who the at-fault parties are, or you may determine that there are more at-fault parties than you initially knew about. When that happens, and more than 2 years have passed since the statute of limitations began to run, you can't add those parties, okay? You're out of luck. So it doesn't matter how good a lawsuit you have or how terrible the facts are. If you don't file your lawsuit within the period of time that's allowed by the statute of limitations, you're out of court. You can't proceed. There are very few exceptions, one being fraud, but fraud is very difficult to prove. So for the most part, when something happens, that's a reason why you have to get to a lawyer right away to assess whether you have an actionable case and make sure that that case is filed within the 2 years that are allowed. Now, medical malpractice cases are a little different. Medical malpractice cases for many years in Florida have had a 2-year statute of limitations, which begins to run when the injured patient knew or should have known that they have sustained an injury that may be related to medical negligence. That statute of limitations begins to run at that point. Now, there has long been a statute of repose that's associated with a medical malpractice action. Most other lawsuits, most other types of negligence actions, not property damages, rather not product liability cases, but most other types of negligence actions don't have statutes of repose, okay, but the medical malpractice cases do. And it has long been the practice that you have a 4-year statute of repose in medical malpractice actions. So what that means is, let's say that in the year 2020, okay, you had surgery and the doctor left an instrument, a forceps, inside of you. It happens. And you don't find out about it until 2025. 5 years have gone by. That means that even though leaving an instrument inside of you is what we call presumptive negligence, or there's an inference of negligence that occurs when an instrument is left inside of you, or any foreign object is left inside of you in a medical malpractice action. However, since more than 4 years have passed, you can't bring your lawsuit. You're out of luck. Again, there's a fraud exception, and there are certain exceptions for children under the age of 8. But in any event, you still only have 2 years from when you learned about the medical malpractice, meaning when you learned that you suffered an injury that may be related to medical negligence, that you have to bring that case. You don't get 4 years. You have to get it within 2 years of when you learned about it. So that's something to keep in mind. You never have more than 2 years unless you're able to prove fraud. Now, again, in medical malpractice actions, they're very unique and they have their own set of rules. And in Florida, you can get a one-time 90-day extension of the statute of limitations by asking one of our circuit court clerks for it, where the action would ultimately be brought, meaning where you would file that lawsuit, you would ask the clerk in that particular jurisdiction to issue you a 90-day statute of limitations, extension of the statute of limitations. So that's one of the few reasons, one of the few ways that the statute actually gets extended, and it only applies to medical malpractice actions. Now, each statute of limitations can vary. Okay, if you're suing a governmental entity, there are other requirements in addition to just filing your lawsuit. You also have notice requirements that, in effect, would take precedence over the statute of limitations, meaning that you have to give written notice within a certain period of time to the designated individuals if you're going to be bringing an action. Now, those types of cases usually occur when you're talking about either cruise lines, which have specific requirements that are in your passenger ticket, which you need to read very carefully because those are very short notice limitations, usually 6 months to give notice and 12 months to file your lawsuit. And that's shorter than what would be the general maritime statute of limitations, which would be 3 years. So that contract of carriage, meaning your cruise ticket, shortens your statute of limitations, and you have to be very aware of that. Now, in the case of governmental entities, such as suing the city or suing the county or suing the state or suing the sheriff's office, you would have a certain limited number of years within which you must give them notice. And then after that notice period, you can file your lawsuit. But the notice period is always going to be shorter than the statute of limitations period. Now, you have to keep in mind, okay, that these statutes, okay, as I mentioned earlier, will prevent you from bringing a case regardless, okay, of how good of a case you may have. So you have to be very much aware, okay, of the period of limitations when an injury occurs. So to kind of sum up here, if you've suffered a personal injury in Florida after March of 2023, you have to act quickly because you only have 2 years on your statute of limitations. And missing that deadline is going to be fatal to your lawsuit. Okay. Now, we talked about statutes of repose, and I very briefly just want to circle back and talk about product liability claims in Florida and the statute of repose. That gets a bit complicated, and it's a relatively recent addition, and it's something that's not contained within Florida Statute 95.11. It's contained within Florida Statute 95.031, subsection 2. And what that basically states is that there's a strict statute of repose on product liability claims, and that no action for personal injury, including wrongful death based on product liability, can be brought if the harm occurs more than 12 years after the product was delivered to its first purchaser or lessee. Meaning that if you're dealing with an old product, okay, there are going to be other time limits that you have within which you must bring a claim. Now, that claim may not even be brought in certain circumstances. Now, this is going to apply to most products, and the products that it applies to are those that have a presumed expected useful life of 10 years or less, with certain exceptions for aircraft or boats or railroads, because those are expected to last longer than that. But the key point is that the 12-year period begins when the product is first delivered to a consumer, not when you purchased it or you used it. If the injury is caused by a product after this 12-year period, the claim is generally barred regardless of when the defect or the injury was discovered. There are a few exceptions. If the manufacturer had actual knowledge of the defect and concealed it, then that repose period may not apply. And if the injury itself manifests itself, meaning you become aware of it after the repose period, but you were exposed or used the product within 12 years, that claim may still proceed. Now, if the manufacturer specifically warranted a longer useful life than 10 years, rather than 12 years, then you can proceed with that action as well. It does not happen all that often. So what happens in effect is that the statute of repose provides manufacturers and sellers that after 12 years, they'll not face new lawsuits over their products, even if the defect is discovered later. Okay. For consumers, this means that waiting too long to bring a claim, even if the defect was unknown to you and was not immediately apparent, can result in losing your right to bring a lawsuit. So it's important, okay, that you meet these strict legal deadlines, which can bar your claim. So again, okay, not to belabor the point, but once you're injured, okay, or once you become aware of an injury, you need to get legal advice as soon as possible to determine what your statute of limitations is, so that you know how long you have to be able to bring that lawsuit. Now, I can also say as a practical matter that you don't want to wait until the end of that period of limitations, because if your lawyer is going to investigate the claim, he needs some time to investigate that claim and its merits, especially in the case of medical malpractice cases. So you have to leave enough time in order to investigate the claim. You can file up to the last day, obviously, but it's the best practice to get your legal counsel as soon as possible. Thanks for listening. If you have any questions, I can be found on the web, and I'll be happy to answer any email questions that you want to send to me to the best of my ability. Have a great day.